Okay, good morning, good afternoon, everybody. Again, my name is Nathan Dean. Welcome to the Washington Policy Pulse. Joining me is Justin Teresi and Jennifer Ree. We're going to be talking a little bit about things that they've been writing about. We're going to talk a little bit about what I've been writing about. We're going to talk a little bit about what you can anticipate from Congress in the next few weeks. But let's go ahead and start with Jen Ree. One of the reasons why we wanted to bring Jen on is because last week we saw some headlines about the Capital One Discover Financial Services merger and that subsequently Capital One's stock price took a decline as a result. So, Jen, I wanted to bring you on and just ask you, what are your thoughts about what happened? You subsequently put out a note on it. You know, one of the big questions is Capital One going to be able to get Department of Justice blessing on this merger? So I'm going to turn it over to you to give us your thoughts.
Yeah, sure. Thanks, Nathan. My gut reaction is that things are still looking pretty good for this deal. Now, we're at a crossroads right now with the Department of Justice. We have new people coming in. We have staff attorneys that are, that have been there, that are legacy. They may still kind of be operating under the policy priorities or the thought process, the goals of the predecessors of Trump's folks. You know, it's hard to say at junctures like this what's going to happen, but my feeling about this is that we have a new Assistant Attorney General in charge of antitrust. She just started March 12th. Her name is Gail Slater. And I just tend to think she's going to take a bit of a different approach than Jonathan Cantor did, who had her position during Biden's administration. And I believe she'll be more reticent to bring lawsuits against deals where it's just not really a sure thing in court, or at least a very good shot at winning in court. And I don't think this one is. So let me just say first, it is uncommon for the front office of the Department of Justice, front office being really the decision makers, to go against the staff recommendation. And the news that we got last week was that the staff was still recommending to sue to block the deal because they perceived it to be harmful in a subprime lending sector, lending to folks that are considered subprime, that the combination of the two there would create a concentration where there could be harm to these folks. It is uncommon for the front office to go against staff. It happens. It has happened before, but rarely. But as I said, we have this strange situation where we have Gail Slater just coming in. She doesn't have a working history with most of these people who are on the staff. She has different policy priorities than her predecessors, and she may decide to be independent on this because of those things. Interestingly, the last time I know of that the front office made a decision that went against a staff recommendation was when we were exactly in this place the first time Trump was elected to be president. The DOJ staff recommended against suing AT&T's proposed merger with Time Warner. They were ready to sign the settlement. I understand they were any minute they were going to sign it, and Trump's new Assistant Attorney General in charge of antitrust, Makan Rahim, took his position and said, no, I want to sue. A lot of people thought this was because CNN was a Time Warner property and Trump was antagonistic towards CNN, viewed CNN to go against him, and that's why they went ahead and sued. So that's the last time I know of. I mean, normally it's confidential when these things happen, but I know that at that point, the Trump administration did go against the staff. They brought that suit and they had lost that suit. Now, we don't have much of a track record for Gail Slater, as I mentioned before. And she didn't say very much prior to her nomination about what her priorities would be as AAG. So we're guessing a little bit here, but my research suggests that she's someone who's pretty measured and strategic as an attorney, and I don't think particularly reactionary in her approach. The one thing that she has said is that she is willing to go ahead and settle deals that she thinks raises antitrust concerns, and that is different from what we saw in the previous administration, and also suggests to me a return to a little bit more of a conventional enforcement approach toward M&A, which was where a deal raised antitrust concerns to settle the deal and, maybe divestiture, maybe behavioral promises post-merger, and let the deal go forward. Now, the reason why I think she may go against, if in fact the staff is recommending to sue here, the reason I think she may go against it is because I think it would be a really tough case for them to win in court. The reason for that is because even in this narrow market that possibly would be defined by the DOJ, a subprime lending sector, we think that the market shares suggest a deal that only marginally triggers the thresholds that the DOJ uses to make a presumption that a deal will be harmful in the future. So they basically use the combination of market shares as well as a mathematical equation that gives them numbers for how concentrated the market will be. And when that number exceeds a certain threshold, they believe it depicts a deal that could be harmful. The more those numbers exceed the threshold, the more likely harmful the deal is. In this case, it is marginal. It's just above those, it just triggers those thresholds. And where you have this sort of marginal or borderline presumption of harm, but very, very strong pro-competitive aspects to a deal, usually a judge will weigh those two against each other. And we do believe there's some very strong pro-competitive aspects in the payment processing sector here, where we basically have a duopoly in payment processing that's had needed competition for a lot of years and has had a lot of problems with antitrust regulators ever since I can remember, and I've been was practicing law. So while the DOJ may not give as much weight to the pro-competitive side, usually a judge will. And I think the companies, if they were sued, could go into court and make some very good arguments here that this deal weighs pro-competitive. Now, having said that, there are just two things that I have to note, that if there was a lawsuit and the companies chose to fight it, they would have to extend their deal end date, because all of that cannot get done by May 19th. So it's contingent on them being willing to and able to extend that end date if in fact they get sued and want to fight. And then the last thing I want to mention is that outcome here may depend in some part on Capital One settling an unrelated suit that was filed against it. This was March 7th. It's a suit that was filed by several Trump-affiliated business units, and they accuse Capital One of closing accounts without notice for political reasons after the events of January 6th. Our view of this case, my colleague Elliot Stein has written about it, is that it's really a weak case, and Capital One, if they fought it, could probably get it dismissed even before going to trial, and certainly could win in trial. But it does put the deal on riskier grounds as long as that suit is sort of hanging out there, and it might require a settlement in order to proceed with the deal. So we wouldn't be particularly surprised if in the near future we saw a settlement there and then, allowing this deal to go forward without a lawsuit. But again, I want to stress the fact that Gail Slater's new. We don't know what her priorities are really yet. She doesn't have a track record yet. So I'm just going on my research about the type of lawyer she's been in the past, which leads me to believe that she wouldn't bring a suit where she doesn't have a really solid chance of winning. And I think that would be this one.
Okay.
So with that, Nathan, back to you.
Great, thank you. And just from the financial regulatory side, I think all of the fireworks, if you will, are on the DOJ side. I don't think we're going to see much opposition from the Federal Reserve, the Office of Comptroller of the Currency when it comes to this deal. So fortunately, whenever this thing happens, I can just go to Jen and say, I think you are the one that has to deal with the fireworks. But just as a thing, when this news story broke out last week, Capital One was at around 172. It subsequently declined to about 160. And then as of 10 minutes ago, it was at 179. So Capital One has not just recovered, but it's gone up since then.
Yeah, so, and Nathan, what I should say really quickly, just because something you said there, because people don't understand the procedures here, but even if the federal banking regulators approve this, the Department of Justice can still sue and block it. And what happens is if the regulators approve, the Department of Justice has 30 days. It can't close for 30 days. And if the Department of Justice files a suit within that 30 days, they cannot close the deal until that litigation is done. So just procedurally, that's how it would work. Okay, that's all I have to say.
Great, thank you. Okay, Justin, so last week we saw President Trump fire, legally or not, still I think to be determined, fire 2 Democratic commissioners from the Federal Trade Commission. What does this mean for companies like Amazon and Meta?
Yeah, thanks, Nathan. So really, obviously, a very surprising move, I think, to many last week with the firing of Democratic Commissioners Alfredo Bedoya and Rebecca Slaughter from the FTC. And while that's surprising and certainly raises a whole bunch of constitutional issues that are sure to be litigated, our take right now is that the actual impact on existing cases like those against Meta, Amazon, and pharmacy benefit managers like United Health's Optum, CVS's Caremark, and Cigna's Express Scripts, those kind of remain unchanged, at least in the near term. For practical purposes, I think what we see is a reduction in dissenting opinions from FTC commissioners if these firings were to stand. And in those very limited circumstances where you might see some crossover between, let's say, one Republican commissioner to join two Democratic commissioners to sue to block a deal, maybe that makes a difference in that circumstance. But at the end of the day, with the confirmation of Mark Mader, which is expected from the Senate, there was still going to be this 3-2 majority of Republicans to Democrats at the FTC, which gives them complete control of the agenda moving forward and would have allowed them to make moves like settling deals anyway if that's something that was on the table. So what does this mean for the cases that exist? Just a couple of examples. The FTC is scheduled next month to begin its trial against Meta, which would seek the divestiture of Instagram and WhatsApp from the company for saying that the purchases of those companies by Facebook at the time, now Meta, were in and of themselves anti-competitive. Let's just say there was some kind of settlement arrangement that came about before the trial started. Not saying we have any reason to believe there would be. FTC Chair Ferguson has said, no, we're full steam ahead and going to trial. But if there were, there would be a 3-2 majority likely in place by April anyway to accept a settlement offer or work around the edges of something like that. So again, while we might not see a dissent on that, if that were to actually happen, the actual outcome would be likely unchanged. And there's been some conversation about how this might affect the FTC's case against the PBMs, the pharmacy benefit managers, because Chair Ferguson and Commissioner Holyoke, the two Republicans who are still at the commission as of now, had recused themselves from that case when it was filed back in September. But the reality is Senate confirmation of Mark Mader could be coming any day now, and once he's there, that gives them one single unrecused vote to actually vote on what's happening with that case. And our reading of FTC rules is that if there's one commissioner, if there's the quorum constitutes any number of commissioners, a majority of any commissioners who are not recused from a particular matter. In this case, it would be one, and it'd be 100% of one if Mark Mader was voting on anything related to the PBM case. But that case is in the throes of discovery right now. It's deep into litigation. The actual need for the commission to vote on something anytime in the near future looks like it's kind of far off. So again, Mader is likely in place before there's any need for the commission to step in and do anything with regard to that particular case. A bigger issue, we think, realistically, is resources at the commission, right? So we've heard a lot of talk about DOGE cuts government-wide, and the FTC really hasn't been spared from that necessarily. We know there have been probationary employees that have been cut, including in the Competition Bureau at the FTC. So that being the case, it looks like things are a little strapped. We saw a run-up of a lot of cases before Chair Khan left the door in January, some cases that the existing FTC Republican commissioners were opposed to at the time. So we've said all along, it's probable that some of those cases might be discontinued, more likely that a settlement of some kind, a lighter settlement will be reached with the cases like those against John Deere and PepsiCo that were filed in January. And if they are, that's something we were expecting anyway. Again, the firing of those two Democratic commissioners, practically what it does is removes a dissent and perhaps some transparency as to how those deals came together if they're reached. But again, we think they're going to happen anyway. And constitutional challenges here, they are what they are. They're really rolling out. They're coming on several fronts, but that's kind of where we are. And there's a whole bunch of things here that we have had to see in the coming months.
Great, thank you, Justin. So what do we have going on the rest of this week? Well, let me first start off with a confirmation hearing that we have on Thursday over at the Senate Banking Committee. This is the confirmation hearing of former SEC Commissioner Paul Atkins, also Jonathan Gold to be the next comptroller of the currency. I think both of them are going to be confirmed fairly easily within the next few weeks, but in particular to Commissioner Atkins, our view over at the SEC is there's really going to be a focus of maybe four things. One is, or three things with one higher theme, crypto, market structure, and capital formation. I mean, you hear these terms all the time. What does this mean? Well, cryptocurrency, the SEC just had a task force meeting on Friday. Look for the SEC to begin to promulgate ideas of what is a security. Because remember, the SEC just has authority over securities. And so they're going to try and make sure that there's additional guidance for companies like Coinbase and Robinhood of what is a security obviously you're going to need Congress to do the rest of it in terms of commodity status and so forth. Market structure regulation, obviously, Commissioner Atkins, when he was in the SEC in 2005, wrote a big dissent about Reg NMS. This is National Market Structure, National Market System. And so, this was a regulation that essentially developed what the equity market structure is of today. I wouldn't be surprised if he were to go back and look at that. Obviously, this is more high level, so I don't think this is going to be a priority or a high priority for them, but don't be surprised if they were to look at this. And this idea of capital formation, whether it's changing the definition, what it is an accredited investor, making sure that crowdfunding is a little bit easier to do, cutting regulatory red tape, looking for companies to be able to access both private credit and also to go to an IPO. This is something that I think you're going to see a lot of rulemakings over the next 2 years. That one theme, though, is look for more of a return to a principles-based regulation as opposed to prescriptive. This is the idea. This is sort of the same thing that we have over at the Commodity Futures Trading Commission, where as long as you meet the principle of the rule, the agency is like, great, good, go forth, as opposed to dotting I's and crossing T's and getting into the specifics of it. So I think that's one of the major themes that you're going to see over at the SEC. Also going on, we just put out a note on the Farm Bill. It's not too early to talk about the Farm Bill. Yes, I know the Farm Bill expires September 30th, 2025, but we've started our initial look at it. This is important if you have exposure to the grocery store, so like Walmart, Kroger, Albertsons, because a good portion of the Farm Bill is SNAP benefits, food stamps. And at 25% of Walmart's grocery store revenue is related to SNAP benefits. It's a little bit less for Kroger and Albertsons, around 9 and 7% respectively, but we're talking a significant amount of money here. Now, our initial look at this, and obviously still with the caveat that we're still many months away until this is debated, our initial look is that we think most of that SNAP-related revenue is safe, or there's not going to be a material change. Glenn Thompson, he's the chairman of the House Ag Committee, has already gone out and said, look, I don't think we're going to be cutting SNAP as part of the Farm Bill debate. And then additionally, Republicans have been looking for a $230 billion cut to SNAP as part of this tax reform debate. And Chairman Thompson said he's not exactly sure that's going to happen either. So as of right now, we think that revenue related to those grocery stores is safe. Other things to keep in mind, there's a lot of news headlines about the FHFA right now and Fannie and Freddie. I can point you to those, but essentially the Doge and also the new leadership is moving into there. And so, you've had headlines like Treasury Secretary Scott Bessent saying that potentially they'll privatize those, include them in a sovereign wealth fund. Other headlines like, look, they're looking to do restructuring. Several members of the boards were fired. So just keep this on your radar. We're going to have additional thoughts on this out in the next few weeks, but I wanted to just keep you in the loop, because I think the headline risk, or at least the headlines, are going to continue with Fannie and Freddie probably for this week and next week, if not a little bit longer. And then the last thing I want to talk about is what are the Republicans in the House doing right now? So Congress returned back this week. They are here for 3 weeks until they leave for the Easter recess, or Fairfax County spring break for me. But what are the Republicans going to do for the next 3 weeks? This is where Speaker Johnson has said that they are going to come up with a plan to come up with this $4.6 trillion tax extension. And so if you're looking at Medicaid, if you're looking at the Inflation Reduction Act, if you're looking at any additional of these tax credits, the next 3 weeks are going to be crucial, and you're going to see a lot of headlines. Now, I don't think the Republicans can get there. They want this done within 3 weeks. I don't think they can get there, and there's nothing that says they just can't kick the can and continue this discussion another day, but I don't think they're going to get there. But you are going to see headlines coming out of Washington about this, so keep that in mind. The specifics, we've always been talking about the specifics of this blueprint of the budget resolution. The specifics are coming over the next 3 weeks. Now, what's happening over at the Senate? Well, obviously the Senate, they're not really a part of this. This is the Senate Republicans. Senator John Thune, has already passed his two-bill resolution, but he hasn't really passed the one-bill resolution. And so this is where there's sort of a disagreement between the House and the Senate. The Senate still sort of feels that they're going to move forward with a two-bill resolution here, a two-bill reconciliation package, because they don't believe that they can get agreement on the taxes, 4.6 trillion taxes, anytime soon. The one caveat here is, and this is the discussions that started late last week and they're going to continue, and the Democrats are certainly going to put pressure on this, is they're pressuring the Senate parliamentarian to allow them to change the baseline of this reconciliation debate. Remember, I've always said in the past that in order to do this, you have to make it budget neutral, got to get it close, and it's going to cost $4.6 trillion. Now, the Senate Republicans, not all of them, but some of them are saying, going to the Senate parliamentarian and saying, look, instead of $4.6 trillion, the current policy is the current policy, and as a result, the price tag should be zero. And so if you're trying to make it budget neutral off of zero, then obviously you can do a lot of things much easier. So look for that debate to play out over the Senate parliamentarian, because the Senate parliamentarian is the one that ultimately decides if that's the case or not. Obviously, you can get rid of the Senate parliamentarian and get a new one, but senators generally don't want to do that. And also, if you go that route and you declare the baseline is zero, then you're most likely going to have a deficit-inducing package either, and that's going to be very difficult for Republicans in the House. Currently, the Republicans have a 218 to 213 majority, and so just keep that in mind. They can only afford to lose 1 to 2 votes at this point. So I apologize that we've run a little bit longer, but we had a lot of great information that we wanted to get you today. I just want to say thank you again for attending. If you have any feedback on these, if you'd like for us to change the format, talk a little bit more, talk a little bit less, just please reach out to me at ndean10@bloomberg.net. Really want to wish and get your feedback and incorporate that. But again, thank you very much, and wish you a great day.